Good morning, everyone, and welcome back to our monthly webinar series. I'm Yam Menon with the Connecticut Charter Schools Association, and some of my colleagues from our team have joined. For each webinar, we focus on specific topics, as some of you know, as we work to respond to the sector's needs. And this morning, we're going to hear from folks on the topic of labor and employment law for schools during the pandemic and back to school time. The webinar is going to focus, because we've been getting a lot of questions on this topic, on leave laws and policies. And we have a few questions that were sent in to us, but we also welcome any questions that you all may have as well. So today we're thrilled to be joined by two folks, many of whom you likely know or familiar with from the law firm of Pullman and Comley. We have Mark Samaruga and Zach Shuren. By way of intros, Mark has spent nearly 3 decades, although he's very young at heart. He's very young. He's very experienced, proudly representing the interests of public agencies and schools and employers in the state. He has a ton of experience in counseling, representing public and private sector clients in labor, employment, education, municipal law, and charter school issues, and he literally wrote the book on FOIA matters in Connecticut. Like me, he's a graduate of UConn Law. We've got 2 fellow Huskies here, and a graduate of Trinity College. Zach's practice includes collective bargaining agreements and negotiations, representation at grievance and interest arbitration hearings. So again, a lot of labor and employment experience, advocacy before state and federal courts, representation in student expulsion and residency hearings, and so forth. He represents clients amongst a wide range of administrative agencies and a lot of experience engaging at the state level. And again, Zach is also a graduate of UConn Law and a graduate of Hamilton College. So before we dive into the webinar, just a few minor housekeeping notes. This will cover labor and employment law and leave policies, and we'll address some of the personnel questions that some of you have been sending in to us. And a reminder to folks for the school leader meeting, we will be hosting our quarterly school leader meeting on Thursday, October 8th at 10 a.m. That's 3 weeks from today. And we'll resume our monthly webinar series later in the month. So if you have any questions or content that you want to see covered for future webinars, feel free to just mention that in the chat here or just contact us at any point. And then a final note with respect to special session, that there is a chance that the legislature might call another special session. We'll keep a close eye and we'll let you all know as we hear more, especially as it includes any potential impact to charter school funding, if in fact that happens. So without further ado, let's welcome Mark and Zach, and thank you both again in advance for your time this morning. You know, these folks are not only Connecticut charter school experts, but they really understand the environment that we're working in, and they've really stayed on top of what has been a rapidly changing legal climate here. So, so with that said, I'm gonna turn this over to Mark and Zach. This is my cue to ask you to unmute yourselves, and please take it away.
Thank you very much, Yam. I gotta offer one caveat. Everything I'm saying right now is based upon the guidance that is in existence as of 10 o'clock on today. And there's no guarantee that this guidance might not change like literally within hours. That's been the whole experience during this entire COVID-19 period of time. Now, just generally speaking, we're going to talk about leave issues, but also accommodations. And, you know, one of the major accommodations people ask about are requests for remote assignments. Now, generally speaking, there's 2 types of issues that lead to these requests. One is, you know, the employee's own health concerns, and there are specific statutory guarantees and protections and issues that regarding an employee's own health issues that they might have, but also circumstances involving family members. And not only health, but we all know because of the situation with schools, a lot of people have schools that are not open full time, and there's a need for childcare. Here's where the part where I have to often try to protect people from their own decent instincts, humane instincts, Every case should be dealt individually. However, always be careful about setting a precedent because, as they say, no good deed goes unpunished. This exists both in the unionized workplace, and I know there's a couple of charter schools that have a unionized workplace in Connecticut, but also the non-unionized workplace, because if you treat people differently, there might lead to a claim of discrimination. As we always say with these leave issues, the key is, form should not be elevated over substance. Sometimes people don't say the magic words of, I want an accommodation under the Americans with Disabilities Act, or I need leave under the FMLA. So don't try to be too cute on this. And last but not least, very important thing is people's privacy rights. You need to be protected. Now, there are times when we deal with COVID-19, there's times you have to provide information in the workplace about, oh, there's been an exposure. But it's always important to protect the privacy rights of the individuals. Okay, the slides work. This is the alphabet soup. I give credit to Zach for the visuals on this one. Again, there's a bunch of acronyms, and that's what lawyers do, is we deal in acronyms. The basic ones, the Americans with Disabilities Act, which deals with accommodations, also known as ADA, the Family Medical Leave Act, which may be applicable to some of the charter schools, and I know it may not be applicable to others. The big one is the Families First Coronavirus Response Act, which has two parts of it: the EPS, the Emergency Paid Sick Leave provision, and also the EFMLA, which is expanded which is basically FMLA, which is really mainly tied to childcare issues. There's the Connecticut Fair Employment Practices Act in terms of discrimination. The EEOC for Equal Employment Opportunity Commission, which is the federal agency. I left out one, which is CHRO, the Commission on Human Rights and Opportunities, which would deal with discrimination claims in the state. Very first slide is the first part of the Families First Coronavirus Response Act is the EPSLA, which is the Emergency Paid Sick Leave Act. And this provides up to 2 weeks or 80 hours for the following, the paid leave. And there's two types of it. One part is, if an employee is subject to a quarantine order or a stay-at-home order or a self-quarantine order, it's full pay, but there's a $511 per day cap. This also applies to someone who's experiencing COVID-19 symptoms and is seeking medical attention, because you don't want a situation where someone may have COVID-19 and hasn't gotten a diagnosis yet. They don't want that person coming into work. So this protects them. Now, in terms of these types of requests, you're not permitted to seek medical notes to support a request for leave under the EPSLA. Here's my first example. Since, in terms of a very common question, what happens when an employee takes a vacation to a quote unquote hotspot? And people have always said to me, the person voluntarily chose to go to a hotspot. Why do we have to give them leave if they have to, quarantine? And the answer is because of the statute. Now, there is another thing you should think about is, as things are fluid, there's been some change in the guidance in Connecticut for self-quarantining, where there may be an exception for people having to quarantine for 14 days from coming back from a hotspot if they take within 3 days, 72 hours of the return or upon the return, a COVID-19 test and it's negative. So you may want to be in a position of wanting to require employees, as a condition for them taking vacation, is that they require them, if possible, to take a COVID-19 test before their return. So you could have maybe avoid the quarantine issue. Another part of this is there's the full pay, but there's also the 2/3 pay. This is capped at 200 hours per day. Is basically for either you're caring for someone subject to a quarantine, maybe someone in your house, or your own child, when your place of daycare or childcare is closed, and the childcare provider is unable to, is unavailable due to reasons related to COVID-19. I would stress this, and this is recent guidance, that this applies not only would apply, even though in theory it doesn't apply to what's called intermittent leave. There is no intermittent leave. The Department of Labor said that this does apply, that say you have a situation where your child is at home 1 day a week or 2 days a week because of, a hybrid model. This would be, leave would be available to you under these acts because of that. Next, this is part of and parcel. There's the 2 weeks. There's also a provision of 10 additional weeks specifically for the child care issues if a child is at home due to school being closed. And again, this would apply to situations if a child is at home because they're on a hybrid model. So they'd be eligible to receive this leave, up to 10 weeks of leave. Again, it's capped at 200 hours per day. Now, it's not available if the employee is teleworking, and some of you are, may have still employees who are teleworking. If they can telework at home and take care of their child, they don't need the leave because they're doing their job and you're paying for them. Now, one example is here that while it's available if you have a child who's on a hybrid school model, as I mentioned, and the child needs to be home on days because the school is not open or it's for that child, if the child's school is open, but they're electing to have them take remote instruction, this leave is not available to those parents. Now, the Americans with Disabilities Act, ADA, this is going to deal mainly with an employee who has a health issue. There's a requirement that you engage in what's called an interactive process for those who may have a qualifying disability and determine whether there's a reasonable accommodation that would enable the employee to perform the essential functions of his job or her job. And the same thing exists under state law. What does this all mean? An interactive process means what it may say is that an employee may request a specific accommodation. You're not required to give them the accommodation they want, but you're required to at least have to continue the discussion. Now, under the ADA, unlike the emergency FFCRA leave, you can require a doctor's note to support a request for an accommodation. Again, you don't have to specifically say, hey, I need accommodation under the ADA. If they're requesting an accommodation, you have to try to honor it. Now, you're not required to create a position that does not exist as an accommodation. But examples of what may be a reasonable accommodation under the circumstances would be an unpaid leave of absence above and beyond what may be available under the FMLA or the FFCRA, transfer to an available position, again, available position, or maybe adding equipment to a working area or assigning an employee to a different work area if feasible. Those are reasonable accommodations. Now, remote instruction. We've had a lot of requests especially from teachers saying, I don't feel comfortable coming to school. Can I teach from my house? And a remote teaching position may be a reasonable accommodation if it is available and if the teacher is certified for the position. You are not required to create such a position. In other words, you have enough opt-out students where you might need a remote instructor. You could provide that position. And there may be circumstances from a practical standpoint. I've had clients say, I have a teacher, for example, special education, a speech language pathologist, or for example, a Spanish teacher, and I can't replace them. There may be a circumstance where it might be worth trying, having the person provide remote instruction, but you're not required to provide it. And there's a danger if you do provide it. I would point out in a unionized workplace, if you allow someone to provide a remote position where it's not you're creating, you may be setting a precedent. So you may want to consider a memorandum of understanding to address this situation. In all workplaces, be careful, because if you provide remote opportunities to certain teachers, but not other teachers, the teachers that don't get them could claim, I'm not getting it because of my race or my gender or my religion. That creates, discrimination issues. So be very careful. Now, the Family Medical Leave Act, you see here a little asterisk, because I know some of the charter schools, this may not apply to them, because this applies in terms of eligible employees. You must have a workplace where you have 50 or more employees at that site or within 75 miles of the work site. This may apply to some of the larger charter schools. It may apply to those who are part of networks within 75 miles, but that's a limited group here. For those who it does apply to, there's a provision of 12 weeks of unpaid leave and continuation of insurance and a promise to return to a similar position. Now, again, just because someone doesn't say, hey, I want leave under the FMLA, doesn't mean, hey, they're not making a request for FMLA leave. Okay, reasons for FMLA. Now, we have highlighted ones that might be COVID-19 related. You can see the rest on the screen. but you know, to care for a spouse or a son or a daughter or parent who has a serious health condition, or if you have a serious health condition. Now, keep in mind, the FFCRA was largely created because the FMLA was deemed not to cover everybody. And first of all, I should have said the FFCRA applies to any workplace, is for any employee who's been working at least 30 days. You know, unlike the FMLA, which has a limited group of people to it applies to. I give it an example: someone who has lung disease and is unable to wear a mask. That prevents the person from working during a COVID-19 times. You know, there's a question. I mean, you have an obligation to accommodate someone with a serious health condition and provide this leave under the FMLA, but you're not required to provide leave for someone being a simple fear of an illness. There has to be something more concrete than just, I'm afraid of getting it. There must be some health issue. Now, about concurrent leave, you can require, if a person is eligible for FMLA leave, to use their sick time while on FMLA leave due to their own serious health condition. Now, the question is someone have a serious health condition, and is someone sick and eligible to even use paid sick leave? Because FMLA leave's unpaid. Sick leave, if you're using it, is paid if you have it under a contract or a collective bargaining agreement. And again, fear of an illness may not justify sick leave, but there may be something in the past, for example, where people have had cancer and you've allowed people to be out and use sick leave because of that, because of their exposure. That may be a past practice. They may be eligible for sick leave. So again, is it a current illness or a concern? And that may justify whether someone is able to use it. Now, I would say if someone's eligible for FMLA leave, please start the clock as soon as possible. So, because there's 12 weeks, you want to start the clock as soon as possible so you don't have a situation where someone is out, then you have to give them 12 weeks after. And I would say the sick leave analysis is applicable even regardless if the FMLA is not available. If you have a contract, non-collective bargaining agreement that provides sick leave, whether the person is sick or not, or has a fear of an illness, will determine whether the person is eligible. My last slide here before I turn it over to Zach, i.e. the person with the more knowledge here, is for those in the unionized workplaces, and there's a couple of you who have unions, that collective bargaining agreements may have specific language that discusses what employers are or not required to do when facing leave requests. There may be provisions not only dealing with sick leave, but special leave requests. Unpaid leave above and beyond what exists. You know, you always have to determine whether it's provided under the contract or whether there's a past practice. Now, if there's nothing under the contract, collective bargaining agreement, or a past practice, but you wish to provide an accommodation or leave in a specific circumstance, we think it's a good idea to always have a memorandum of understanding to prevent the creation of a past practice if you're granted a leave of accommodation, such as providing remote instruction in a given circumstance. I'm now going to turn it over to Zach Sharon, who will discuss more of these issues and give a step-by-step analysis. Zach?
Okay, thanks, Mark. Good morning. Mark is the real expert. He's being modest, but I'm happy to help and pick up where Mark left off. So, I think Mark gave a very good overview of the different statutes that we're talking about, the different acronyms, what those statutes provide in terms of entitlements. What I'm going to kind of talk about is sort of what we have as an informal checklist of how to go through the process of when someone comes to you with a request saying, hey, I need to work from home, or hey, I have a childcare issue. How do you handle those practically? So what I'm going to go through are kind of two different checklists that we've sort of developed. These are not hard and fast rules. Every situation is different, but the hope here is that these can help you kind of guide you along and that you can use them as appropriate. Okay, so the first checklist I'm going to talk about is when the employee comes to you with a request regarding their own health condition. Okay, so got their own health condition, not the health condition of a family member. Okay, so the first step in the process is pretty simple. You just want to gather initial information, understand Why is the employee coming to you? What is it that they're seeking? What is their concern? As Mark discussed, general unsubstantiated fears of contracting COVID-19 do not have to be accommodated under the law. There's no ADA protection that says, you know, if someone's concerned or scared about coming back to work, that they're entitled to an accommodation. That's even the case for employees who are in certain high risk categories for COVID-19, such as over 65, pregnant, some other categories. Okay, so step one, gather initial information. Step two is requesting supporting medical documentation if the employee asserts that they have an underlying health condition that puts them at a unique risk. Again, that's different than the unsubstantiated, just general fears. But if they come to you and they say they have some kind of specific health condition that puts them at risk, follow this step two. What you're going to want to do as a first step here is you're going to basically give the employee what's called an ADA, Americans with Disabilities Act, medical certification form with a directive to the employee to take that form to their doctor and have the doctor fill it out. What the doctor is going to do with that form, next slide, please, Mark. What the doctor is going to do with that form is the doctor is going to look at your job description for the position. And this, just a little tangent, this is an advertisement for having updated job descriptions because this becomes very important here. The doctor is going to look at your job description and he is going to make his or her medical judgment as to whether or not the employee can perform the essential functions of his or her position with a reasonable accommodation. So, you know, as part of that process, let's say the employee has severe asthma. You know, the doctor is going to check some boxes and certify that the employee has a disability, the severe asthma, and the doctor may say that the employee can perform the essential functions of his or her position, but with a reasonable accommodation. What gets very interesting and kind of where the rubber meets the road with these medical documentation issues is what exactly is the doctor saying? And is the doctor's recommendation, does it logically flow from what they're saying the underlying diagnosis or disability is? For instance, often medical requests will say that you know, the employee must work from home due to concerns about contracting COVID-19 and the effect on a pre-existing condition. But you know, often that might not be something that logically flows from the opinion. Maybe there are other accommodations short of having the employee work from home that can satisfy the employee's disability and allow the employee to perform the essential functions of their position. So, you know, things like desk shields, teaching in rooms that are bigger than normal, that allow for more social distancing, PPE, that sort of thing. Just because a doctor's note says that the employee should work remotely doesn't necessarily mean that that's the only option. Okay, next slide, Mark. Thanks. Okay, so when the employee comes back to you with the medical certification form, what's supposed to happen under the Americans with Disabilities Act and the Connecticut Fair Employment Practices Act is you, the employer, are supposed to have a meeting with that employee to engage in what's called the interactive process. And that's a term of art under the Americans with Disabilities Act that talks about really an informal dialogue that the employer and the employee have to have in good faith to talk about what is going to be an appropriate accommodation for the employee's disability. One of the key things to remember here, and I kind of talked about this earlier, but just because an employee has a preferred accommodation or a doctor even has a preferred accommodation, that doesn't end the discussion if there's another accommodation that will allow the employee to perform the essential functions of his or her position. So, you know, again, a remote work assignment may be what the employee wants, but you need to think about what other options may be available to allow the employee to perform the essential functions of his or her position. Next slide, Mark. With this interactive process, it's very important you want to keep records of what was discussed, when meetings were held, who attended the meetings, what accommodations were offered, if any accommodations were accepted, how long they'll be in place, that sort of thing. You want to keep good records here, because if, you know, there's a very, if things somehow break down and, you know, God forbid you're in litigation, being able to prove that you as an employer engaged in a good faith effort to find a solution to the employee's issue is going to be crucial in defending against any Americans with Disabilities Act claim against you as an employer. Under the law, if it's the employee who failed to engage in the good faith interactive process, then an employer will not be liable. Next slide. Okay, Mark touched on this, so I won't go over this in great detail, but remote work is a reasonable accommodation. It should only be a reasonable accommodation if such work is available. You as a charter school should not be putting the cart before the horse and creating remote work positions just to accommodate people. That's not the way it works. You are the educational institution. It's your prerogative to determine what you think is appropriate in terms of meeting your needs, in terms of educating students. So you don't put the cart before the horse. Remote work should only be created if you have a need for it. If you do have remote work positions and they are available, then assigning someone with a disability to a remote work position may be a reasonable accommodation. And when you're making that determination, you know, you want to look at things like, what are the qualifications for the position? If you know, if someone is a math teacher and there's a need for a English remote work assignment, and the math teacher really doesn't have endorsement or qualification for that position, then they're not a good fit, and they really shouldn't be eligible to go into that remote work assignment just because it's there. Next slide, Mark. Mark talked about this too, but leave is a reasonable accommodation. An unpaid leave of absence may be a reasonable accommodation in certain circumstances if there are not other forms of accommodation that would allow the employee to perform the essential functions of the position. There is no clear, definite rule under the law of how long is appropriate, but as a kind of rough rule of thumb, 6 months of unpaid leave that's generally considered in the ballpark of what's going to be appropriate. An indefinite leave of absence, where you as the employer just don't know when the employee is going to come back, that is never a reasonable accommodation. Also, you know, be aware, if an employee is going to go on an unpaid leave of absence due to a disability, they should be required to pay the COBRA rate for their continued insurance. You as the employer do not have to continue paying your portion of the employee's premium cost share while they're on an unpaid leave of absence. Next slide, please, Mark. Okay, so this is kind of a related topic, but it goes into the issue of sick leave and whether or not an employee may be eligible for a paid leave of absence under any sick leave policy that you have, or sick leave language in a collective bargaining agreement. The key question here is, are employees eligible to use sick leave where they have a present illness or injury that prevents them from performing the work? Or has the practice with your school been to allow employees to use sick leave when they have concerns about aggravating a pre-existing condition? And that's a little nuanced distinction there, but it's really important when it comes to COVID-19, because if someone, takes someone with asthma, if what they're really worried about is aggravating their asthma condition, that's different than them being unable to actually perform the work. And what's going to be critical here is understanding exactly how you've treated that instance of the possibility of someone aggravating a condition. If you've been kind of generous in the past and allowed that, then there's going to be probably a pretty good case that an employee here is going to be eligible to use sick leave and be paid for a period of sick leave while they're home and not performing work. And for employers with a unionized setting, the ultimate question is going to be, will an arbitrator sustain a grievance asserting that an employee was denied use of contractual sick leave? Next slide, please. Okay, Mark talked about FMLA leave. I'm just going to quickly kind of go over it. You have to look at FMLA leave in conjunction with other issues. One critical thing here, and I think a lot of employers kind of don't realize or recognize this, but even if an employee does not come to you with a request for FMLA, you as the employer can place the employee on FMLA. And Mark was the lead, but we had a big case on this where it's clear that the employer can make the determination to put someone on FMLA, even if the employee doesn't request it. And the employer can put that employee on FMLA leave retroactively to the start of their absence, as long as that placement retroactively doesn't interfere with their FMLA rights. Both of those things are important to keep in mind, because starting the FMLA clock as quickly as possible is important, because it's going to give you as an employer flexibility if the employee is not coming back after a prolonged period of absence. Okay, next slide, please, Mark. Mark talked about FFCRA leave, so I won't go into this in great detail, but I will say that EPSLA, which is the Emergency Paid Sick Leave Act provision, that leave is in addition to any other forms of accrued leave that the employee may have. Next slide, please. All right, so now quickly, I'm just going to go through how to handle employee requests in connection with family members. So this is a whole new checklist to guide you. But the first step, again, gather initial information, figure out why this employee wants whatever they're seeking. And here we use the word job alteration rather than accommodation, because the word accommodation really applies only to the Americans with Disabilities Act. Here, placement in a remote work assignment is never legally required for a request made in connection with an employee's family member. And the reason for that is because the Americans with Disabilities Act and CFEPA, the state law equivalent of the ADA, they don't cover situations where an employee is concerned about his or her family member rather than their own disability. The second step, you're going to want to evaluate whether the employee is entitled to the use of accrued leave, meaning sick leave, personal leave, even vacation leave. Here, you're going to look at, if you have a collective bargaining agreement, what does it say about the use of sick leave for an employee to care for his or her family members? Does it allow it? Does it cap it at maybe 5 days a year, something like that? Here, you want to be very, very careful. I think this is absolutely critical about creating a new, potentially very expensive precedent where you allow employees to use sick leave to care for family members. If you open that door, it's potentially a Pandora's box, and think about all of your other employees who may want to take that option. Before you go down that path, think about whether or not you realistically can do that, both financially and in terms of things like substitute coverage. Next slide, please, Mark. Mark talked about FFCRA leave. I won't go into this in great detail, but I will say that the expanded FMLA piece of this, which is for childcare for students whose school is closed or when they're on hybrid, when they're doing remote, EFMLA, expanded FMLA, is a form of FMLA, which means that there's a cap of 12 weeks, and the use of the expanded FMLA reduces the number of weeks of FMLA that an employee has remaining to them. Next slide, please. With the EFMLA, the expanded FMLA, schools can mandate that accrued leave be used concurrently with the 10 weeks of EFMLA, and that may be a good idea for personal leave and vacation leave, since the $200 per day in EFMLA has to be paid anyway. And it may make sense to say, okay, well, of course, we'll give you your expanded FMLA benefit of $200 per day, but we're going to mandate that you use your personal leave days at the same time. Schools do not have to permit employees to use expanded FMLA on an incremental basis, meaning several hours at a time or days at a time, rather than in the whole increment, but they can allow it if they so choose. The caveat here, and this has been really a moving target, is that now with schools on hybrid, the Department of Labor, as a result of recent litigation, has said that employees with children in schools that have reopened with the hybrid model are eligible to use EFMLA on days when their child's school is closed, meaning remote. Next slide, please. We talked about the FMLA leave issue. A few things to note here. Under state law, the number of hours that are required for someone to be eligible for FMLA leave for paraprofessionals is 950 hours, not 1250. A lot of people don't realize that, but that's something to keep in mind. Generally, employees are not eligible to use accrued sick leave concurrently with FMLA to care for a family member, but you may want to consider consider what your past practice has been and your collective bargaining agreement language, if any. Next slide, please. And the next one, I think. And then lastly, just as a kind of a last thing, you want to consider whether or not your collective bargaining agreement, if you have one, and or your school's policies have any language that give employees the right to have a unpaid leave of absence in extenuating circumstances. And if you are going to allow that, if you have a policy on that, you want to think about things like how long should the leave be allowed for? How's health insurance going to be handled during that period? Who's going to pay for it? What percent is the employee going to pay? What percent is the employer going to pay? Will the employee continue to accrue things like sick leave and vacation leave while they're on a leave of absence? And finally, if you are in a unionized setting, how will things like seniority and step placement work after the leave has completed? And with that, I think those are the checklists, and I think we're ready for questions.
All right, thank you both. There's a lot of important content here, and we did get some questions in. I think some of these questions will hit on some of what you covered, but there might be some nuances in some of these questions that I think it would be helpful to draw out some of that information. So One is it's not specific to leave, but it is around schools. Really, I think they're trying to assess their potential liability with people getting sick around COVID. So one question that's come in is whether schools can require that staff and teachers have to present a negative COVID test to be able to return to work to school. Can they have any sort of like filters like that?
Hopefully. Can you hear me? Yeah.
Yes.
In terms of the guidance has been that generally speaking, from the Equal Employment Opportunity Commission, that the use of tests, COVID-19 tests, is generally permitted in the schools. To the extent that, because you're obviously, especially for schools, but the determination to make sure that there's eliminating safety and health issues. I mean, you have to. There's certain precautions. You just can't do it arbitrarily, and also you have to protect the privacy of that information. But you could, especially if, first of all, someone's returning from either being from a quarantine or someone's returning from illness, clearly you can require them to take, if you wish, the COVID-19 test. Understanding COVID-19 test accuracy has been come into play lately. Zach, anything you want to add to that?
Well, I would just say on the liability piece, a few things. Number one, and Mark, I don't know if you want to add to this, but really, if an employee contracts COVID-19, it's possible that they might have a workers' compensation claim. But beyond that, I don't think there's going to be any general liability for a school for that employee contracting COVID-19. And secondly, with that, I think it's going to be very hard for people to prove where they contracted COVID-19. So that there's kind of a proof issue too. So I don't think schools should be too concerned about the liability piece, as long as you're taking reasonable precautions. If there was an outbreak, I think that might kind of change the analysis, and it's possible that you would have to be more proactive. But generally speaking, I think the liability issue is maybe not the top concern.
Yeah, go ahead, Mark.
I would just say that important, especially if you're following reasonably well, you're following the state guidance, following your reopening plan and your response, you should be in pretty good shape.
It's interesting that you both mentioned that, because that answered what was going to be my follow-up question on liability, which, if in fact a student or a staff member gets COVID from someone at the school, this is assuming they can trace it to the school. Will the school be held harmless, or could they be subject to litigation? And could there be a situation where, if guidelines weren't followed, that school could get in trouble for that?
Yeah, I'll turn it over to Zach because he'll probably have more on this. But two parts about that. If the employee were to get sick, even if they could establish causation that they got it at your school, workers' compensation would be the place where those claims would lie. If a student got sick, I think there could be a circumstance if a school was completely reckless and, not, in terms of disregarding the guidelines, where there could be some foreseeable claim, and maybe Zach can expound on that. If they were completely reckless in disregarding the reopening plan or disregarding the state guidance. And most of your reopening plans have been submitted to the state, and I assume they're complying with the state guidance. If you're doing that, you're probably going to be in a pretty good position. I have no idea if anything's going to come of the legislative act in terms of in Washington, where there may be some kind of broad liability protection. But even if that doesn't exist, I think you'll probably be in good shape as long as you're in good faith following of the guidelines and your policy.
I would agree with that totally. The one thing though is, be aware, this is America, so anyone can sue anyone. So, it's possible that you could get sued, but in terms of actual liability, to me, it seems very remote, as long as Mark said, you're making good faith efforts to address the situation. If you are very concerned about this issue, one thing you can do is you could check with your insurance carrier for general liability and just ask them the question about kind of what kind of coverage you have for a COVID-19 situation, and that could give you some peace of mind.
I think the most important thing you can do through this entire process, I say this all the time with all decisions, when you're making a decision about closing and opening accommodations, is frankly your local public health officials. You should make sure they're always involved and always, when in doubt, follow their guidance. Because if you're following the state guidance in general, and you're cluing in your local public health officials and you're listening to them, you're probably gonna be in a good position from a legal liability standpoint. Understanding, again, as Zach said, people can file a lawsuit at any time. But I think if you combine that and involve your public, local health public officials, that's an important connection to keep in mind during this entire process.
Great, yeah, that makes a lot of sense. This next question hits on some of the content towards the end of the presentation. If an employee is allowed to work from home, but they're taking care of young kids or they're homeschooling young kids and they can't really get their work done, could a school require them or, effectively require them to take a leave of absence?
Hopefully I'm being heard here. Yeah, I mean, the leave available under the FFCRA is available when someone can't do their job. That exists. If someone can't do their job, if they can do their job, they don't need to leave. If they can't do their job, then they will need a leave of absence of some kind. And maybe FFCRA leave would be the leave they take. Zach, do you want to expound on that?
Yeah, I think, God forbid that the COVID thing lasts well into next year or whatever, but you only get the 12 weeks of the FFCRA and the 10 weeks of the expanded FMLA leave benefit. If you have a situation with employees where they've exhausted that benefit and they're simply not doing the work that's expected and required of them, this is an unfortunate answer, I think, but ultimately it might become an employee, discipline matter, because there's an expectation that people perform the work, and if they're not able to do that, especially for a prolonged period of time, I don't know how long you can just look the other way. If you do have provisions where you allow people to take general leaves of absence, yeah, maybe that is a good solution where perhaps, the person is going to be unpaid, but you have an agreement where once COVID is over that they'll be eligible to come back to work. Again, here I would look at, the devil's in the details. What would the terms of the insurance be? If there's seniority, how does that work? That sort of stuff.
Great. Another one is around, and I think, Mark, you provided some good suggestions, like schools and districts really need to be in touch with their local health departments, be, clear about what guidance they're getting. One of the questions has been around school policies, whether, for example, on the subject of PPE and equipment, whether, there should be any specific policy guidance issued on that. Really, should schools be revisiting their policies, and if so, what are some of the recommendations you might have for revisiting policies in light of the pandemic?
Yes, I created a couple months ago, and it keeps getting revised. It's a work in progress, a broad COVID-19 policy, which attempts to, first of all, there may be times you have policies that need to be suspended that you normally would have in place because they're not applicable. But it also does, address the issues of mask wearing, which is, very controversial, and it keeps getting revised, and also provision of PPE. So our firm has created such a policy that is available. So that, again, that's great. Addresses generally, it's like 20 pages, and it addresses the whole variety of COVID-19 issues. Got it.
That sounds like a really helpful resource for schools. I'm curious about this next one. I know, Mark, you had mentioned, we didn't have on the list the CHRO, but I wonder about claims of discrimination. And one of the questions that comes up is whether schools can allow a specific set of employees to come back to the building and keep others working remotely, like those who, bringing back those who are not part of, who are have pre-existing conditions or are under 60. Can they bring those folks back? Are there ways that schools can, in an attempt to maybe limit liability, bring certain groups and not allow others?
I think there's some, and Zach, you can fill in the gaps. I've seen specific guidance on the issue of age, where if you say, simply put, okay, 65 up, you're not in, 65 below, you're in, that kind of a broad thing would clearly be problematic, point blank. Could there be circumstances if you kept a person out because that person specifically presents a health or safety issue, especially when someone has COVID? That might be something, but in paternalistic views that we're doing this for your own good, we think you're over 65, you shouldn't be here, will cause a problem.
Yeah, I would agree. I think it's a kind of a slippery slope, dangerous kind of road to go down. I mean, what if someone is not over 65, but they're immunocompromised? Would they? How do you? You're going to get into, I think, difficult questions about who's in, who's out, and I would have concerns.
Yeah. All right. Well, I'm going to wrap up with this one last question. As more come in, we can let you know. This one is about needs for daycare and childcare, and I know that I know that you had sent some correspondence recently about evolving guidance on childcare, which I admittedly did not fully read. But here's the question. If a staff member or teacher has a child whose daycare has been closed or the school is closed due to COVID and needs to take time off, can they use paid leave for that purpose?
They would have leave available to them under the Families First Coronavirus Response Act and the expanded FMLA leave, which is, I think it's capped at $200 a day. Or two-thirds of your salary, depends which is applicable. So there is leave now available for those hybrid circumstances in light of the most recent guidance. Could there be some other leave available? There could be, but I think an employee would have that, the two-thirds or $200 for up to 10 additional weeks beyond basically up to 12 weeks. Until
all right.
First.
All right. Well, that brings us to our conclusion here. Zach, Mark, thank you so much for your time. This has been a really important webinar and content that I think schools will be continuing to cull through and work through as they deal with day-to-day situations. And I know you all will be dealing with it as guidance is ever changing. So one last final reminder for folks that in a few weeks we'll have our quarterly school leader meeting on Thursday, October 8th. But otherwise, thank you very much to both of you, and thank you for folks for joining us for this webinar. And we look forward to seeing you for the next one.
Thank you.
Thank you.